Hello friends, myself Gaurav Jain and I'm back with analysis of important decisions in the field of income tax. Friends, I'll be discussing today the decision of Supreme Court, latest decisions of Supreme Court in the field of taxation of charitable organizations. We have had two recent decisions from the Supreme Court, both dated 19th October 2022. One in the case of cause title Ahmedabad Urban Development Authority and second in the case of cause title New Noble Society. Both decisions, although applicable to taxation of charitable organizations, but operate in different field. Friends, taxation of charitable organizations has always been a matter of controversy. This is for the reason that at times many organizations having the mask of charity do commercial activities, thereby tend to earn abnormal profits and claim exemption thereof in the mask of charity. And that has led to several amendments from time to time, both under the old law that prevailed under the earlier Act of 1922 and several amendments thereafter, even under the new Act of 1961 till date, with last amendment in 2015. And not only amendments by the Parliament, but also the courts, and more particularly Supreme Courts, have time and again come in to the rescue of the citizens to interpret the provisions relating to charity. And not only the decisions of division benches of Supreme Court, but we will see that there are many larger benches of Supreme Court coming to the rescue of the citizens. And we have had decisions even from 5 judge benches of the Supreme Court, not once but twice or thrice. And even the recent decisions which we will be discussing today are from the larger bench of Supreme Court, that is the 3 judge benches decision in the cases of Ahmedabad Urban Development Authority and New Noble Society. So we will be discussing these 2 decisions. We will be focusing more particularly on the decision of Supreme Court in Ahmedabad Urban Development Authority, which has interpreted the provision of section 215 read with section 11 of the Act, whereas the second decision has interpreted the provision of section 1023C6, which pertain to educational institutions stroke universities. So our talk today will cover what is the ratio of the decision of Supreme Court in Ahmedabad Urban Development Authority, how it has interpreted the various conflicting provisions contained in the Act relating to carrying on of business by charitable organizations, more particularly when it relates to achieving objects relating to which we call per se objects like education, medical, etc., and the residual category of achieving object of general public utility. What are the important highlights of this decision, and what will be the way forward post this recent decision of Supreme Court by various charitable organizations. So with this background, friends, I'll move forward. So friends, as I've highlighted, the Ahmedabad Urban Development Authority decision has interpreted section 215, which was amended by the Finance Act 2008 first, with effect from 1/4/2009, and thereafter by Finance Act 2012, and thereafter by Finance Act 2015, whereby a proviso was inserted in the definition of charitable purpose contained in section 215. Friends, section 215 of the Income Tax Act defines what is charitable purpose. An organization which is incorporated to achieve charitable purpose as defined in section 215 is eligible for exemption under section 11 or under other provisions of section 10, provided subject to satisfaction of conditions of application of income contained in those sections. The definition of charitable purpose encompasses 7 categories. The 6 categories has been held in the Supreme Court as per se categories, which are relief of the poor, education, yoga, medical relief, preservation of environment, preservation of monuments, and last residual category of advancement of any other object of general public utility. So first 6 categories are called as per se categories, whereas the last general category is called general public utility or a GPU category. The purported amendment, which is subject matter of discussion today, which was by way of insertion of proviso to this definition, only relate to the category of general public utility, GPU category, which provided that the advancement of any other object of general public utility shall not be a charitable purpose if it involves the carrying on of any activity in the nature of trade, commerce or business, or any activity in the nature of rendering any service in relation to trade, commerce or business for a cess or fee or any other consideration, irrespective of the nature of use or application or retention of the income from such activity. So broadly, this proviso prohibited a charitable organization incorporated to achieve the object of general public utility to carry on any activity which was in the nature of trade, commerce, business or service in lieu of receipt of consideration by way of cess or fees. So this proviso had been a subject matter of interpretation before the Supreme Court and had led to several confusions. What is the real breadth and scope of this proviso as to when it will apply or when it will not apply, or that when a charitable organization in pursuance of achieving the object of GPU, general public utility, carries on business, whether or not it will be ineligible for exemption of taxation under section 11 or any other provision of section 10 of the Act. So that was the scope of interpretation of this provision. The Supreme Court has categorically held that the ratio emanating from this decision will be restricted only to the last category of GPU and not to per se category, since this prohibition in the proviso is not applicable to per se categories but are applicable only to GPU categories. Now, before coming to the further analysis of this decision of Supreme Court, the second decision of Supreme Court in New Noble Society is not applicable to section 215 or section 11 of the Act or to per se categories in section 215. The scope of that decision is restricted to section 1023C6, which is applicable to universities or educational institutions solely existing for the purpose of education and not for the purpose of profit. The scope of interpretation before the Supreme Court in the second decision was mainly with respect to the meaning of word solely as existing in 1023C6. Prior to the decision of Supreme Court, the ratio was what was the meaning of word solely. There were certain earlier decisions of the Supreme Court, more particularly in the case of American Hotel and Queen's Education Society, where it was held that if the predominant object of the educational institution or in university was education, then it would qualify for exemption under 1023C6. The ratio of that decision has been reversed by the larger bench of decision of Supreme Court in this second case, where it is held that the word solely would not mean predominant object. We will have to give the literal interpretation of the word solely, which would mean that the object should be solely, wholly, exclusively education, and if there is any other object, then that organization will not be eligible for exemption under 1023C6. Friends, I am not deliberating or dilating more on this second decision of the Supreme Court. Why I have highlighted this decision is to just highlight or just highlight that the scope of that decision is restricted to interpretation of 1023C6 only, and where the organization which is also held in the activity of education, which is not claiming exemption under 1023C6, this decision will not have any applicability thereto. In other words, if an organization engaged in the activity of education is not claiming exemption under 1023C6 but is claiming exemption under section 11 as part of per se category under section 215, then that decision will have no applicability and it will be governed by the jurisprudence as prevailing even prior to these two latest decisions of Supreme Court, because these decisions do not impact per se categories including education, medical relief, etc. Are not impacted by both these two decisions of the Supreme Court. So having said that, moving forward to the first decision of Supreme Court in Ahmedabad Urban Development Authority, what is the real import of the prohibition contained in the proviso? What are the conflicts? What are the conflicting provisions in the statute? What was the interpretation given by the earlier decisions of the Supreme Court as interpreted by the High Court that has led to the confusion which led the matter to be traveling to the Supreme Court? Friends, what are the hurdles of interpretation of Section 215 read with Section 11 as to understand the correct import of the prohibition contained in proviso to Section 215? Friends, first aid of interpretation or hurdle in interpretation of proviso is Section 11(1) of the Income Tax Act. Section 11(1) of the Act provides that a property held under trust, any income arising from property held under trust which is applied for charitable or religious purpose will be exempt from taxation under Section 11(1) of the Act. Now, the courts have held that property held under trust would also include business undertaking, and the inclusion of business undertaking as a property held under trust is contained in Section 11(4) of the Act, which precisely says that profits from business undertaking held under trust will also be eligible for exemption subject to satisfaction of certain conditions. Therefore, reading 11(1) together with 11(4) gives a clear indication that a business undertaking can also be held under trust provided profits arising from that business are to be applied for charitable objects. Therefore, holding or carrying on of business undertaking when we read Section 11 read with 4 is not per se barred under the normal provisions of 11(1)(4). So how to reconcile 11(1) read with 11(4) with proviso to Section 215? That was the hurdle prior to this decision of Supreme Court. The second, friends, is Section 11(4)(a), subsection 4(a) of Section 11, which provides that even the profits arising from incidental business activities are exempt under Section 11 provided separate books of account of such incidental business activities is maintained. So therefore, even if a business undertaking per se is not held under trust, there is a different property held under trust, but in order to achieve the object of the trust and incidental business activities carried on, then profits from that activity are also exempt from tax under Section 11(4)(a), provided we satisfy the condition in that section, that is maintaining separate books of account. What could be the incidental business activity? So friends, I'm taking an example of a hospital. The predominant object or the property held under trust is the hospital to achieve the object of medical relief. But in the course of achieving that object, the hospital also carries on the incidental business activity of running a chemist shop or running an ambulance. So in case of a medical, the chemist shop or running an ambulance could be considered as an incidental activity. In case of education, running a canteen, school canteen, or running an hostel, or running a bookstore to sell the books could be an incidental activity carried on in the course of achieving the object of education. In the case of general public utility, the activity of, let us say, the main object is to provide marriage halls to weaker section of the society. Now, as part of that activity, if a catering service is provided, it could be said to be an incidental activity. So Section 11(4)(a) and 11(4). 11(4) provides for exemption of profits from business held under trust, whereas Section 11(4)(a) provides exemption of profits from incidental business activity carried on to achieve the principal object of charity, provided we maintain separate books of account. So Section 11(1), 11(4), 11(4)(a) indirectly permits carrying on of the business. So the issue arises, how do we reconcile these provisions with the prohibition contained in proviso which is applicable to a GPU category? Fourth, friends, was the decision of a larger bench, a 5-judge bench decision of the Supreme Court in the case of Surat Art Sales Society, where the subject matter of interpretation before the larger bench was the erstwhile provision of Section 215, that is prior to insertion of this proviso, which was akin to the definition of charitable purpose under section 215, with the only exception that charitable purpose should not be for the purposes of making profit. So that was the prohibition contained in the erstwhile definition of charitable purpose under section 215. While interpreting this prohibition, the 5-judge bench of the Supreme Court in Surat Art Silk Society held that the prohibition is only on the predominant object of the charitable organization. If the predominant object is to earn profit, then that society organization is barred in section 215. But if the predominant object is charitable, and in the course of achieving that object, if the organization earns profit, carries on business, then that is not a prohibition or a bar to claim exemption under section 11 of the Act read with section 215. So basically, the Supreme Court, while interpreting the definition of charitable purpose, which had the prohibition of not carrying on the activity of profit, impounded the test of predominant object. But this was with respect to interpretation of erstwhile provisions of section 215. So, taking clue from this larger bench of decision of Supreme Court, or relying upon this decision of Supreme Court, various high courts have held that even when a charitable organization is incorporated to achieve the object of general public utility, if the predominant object is achievement of that object, and in the course of achieving that object, the organization carries on any business, any trade, any commerce, and receives any consideration, therefore, then it will not be barred under the proviso to section 215 which we just read. So that was the decision of High Court. By relying upon the decision of Supreme Court in Surat Art Silk, a 5-judge bench decision of the Supreme Court in Surat Art Silk, that we have to see the predominant object, and not merely when an activity of profit or resulting into receipt of consideration is carried on, there will be a bar from claiming exemption under section 11 of the Act in terms of the proviso. That was the decisions of High Court relying upon the decision of Supreme Court. So now these decisions were subject matter to be tested before the Supreme Court. The Supreme Court held that by virtue of insertion of proviso in section 215, there is a specific departure in interpretation of the provisions of section 215 by the Parliament. The decision, the interpretation of section 215, where the test of predominant object was read in, was with respect to the erstwhile provisions of 215 and not the amended provision. There is a specific reason for the amendment, and therefore the ratio emanating from the decision of Supreme Court in Surat Art Silk cannot be read in the amended provisions of section 215. There has to be a specific meaning given to the proviso. The assessees had relied upon the circular issued by the CBDT when this proviso was inserted. In that circular, the CBDT has opined that the reason behind insertion of proviso was that in the garb of charity, there were certain organizations which were carrying on commercial operations, and therefore it is basically to prohibit those commercial organizations to claim exemption that this provision has been inserted. The Supreme Court held that we cannot rely upon the circular when the language of the statute is very clear. We have to understand the reason behind the insertion of this proviso and what has been the movement of the amendments in section 215. We have to see the whole picture while coming to the real reason behind insertion of proviso and to interpret the clear import of this proviso to section 215. So basically they departed from the reliance or the wording of the circular to interpret the proviso. They also departed from the ratio of the decision of Supreme Court in Surat Art Silk, that is the test of predominant object, to understand the meaning of proviso. So therefore, friends, the Supreme Court held that what we have to see, that what was the law prior to the amendment and what is the law thereafter, after the amendment, how the amendment in section 215 has evolved over a period of time to correctly understand the import of this provision. The Supreme Court heavily relied upon two subsequent amendments in this proviso. The first was amendment in the proviso by the Finance Act 2012, which said that this prohibition will not be applicable if the aggregate value of the receipts from prohibited activities, that is commercial activities, is 25 lakh rupees or less in the previous year. That was the amendment, that was the insertion of second proviso by the Finance Act 2012. This proviso was further amended by the Finance Act 2015 with effect from 1/4/2016 to provide that the commercial activities are prohibited unless such activity is undertaken in the course of actual carrying out of such advancement of any other object of general public utility, and the aggregate receipts from such activity or activities during the previous year do not exceed 20% of the total receipts of the charitable organization. So Supreme Court heavily relied upon this amendment, more particularly the first part of the amendment which provided that the commercial activity can be carried on provided it is undertaken in the course of actual carrying out of such advancement of any other object of general public utility. The Supreme Court said why this is important, because this kind of provision even existed in the erstwhile 1922 Act, where the taxation of charitable organizations was contained in section 4 of that act. That section also provided that commercial activity can be carried on by a charitable organization provided that activity is undertaken in the course of actual carrying out of such advancement of any other object of general public utility. So even the old law provided that commercial activity can be carried out provided it is in the course of actual carrying out or achievement of the object of general public utility, and even the subsequent amendment after Finance Act 2008, that is by the Finance Act 2015, also amended this proviso to include the similar condition of carrying out the commercial activity in the course of actual achievement of the general public utility. Friends, what is the commercial activity in the course of actual achievement of general public utility? I can explain it with an example. So if my object is to achieve the object of providing marriage halls to weaker sections of the society, and in the course of achieving that object, I actually let out marriage halls to some sections of the society and receive consideration in lieu thereof, then this commercial activity of letting out the marriage hall is in the course of actual achievement of general public utility. So there could be myriad situations where commercial activity is carried out in the course of achievement of general public utility. I may be imparting some vocational education to poor people. If this object is a GPU category, and in lieu of providing vocational course studies to weaker section, I receive some fees from the students, then this is a commercial activity in the course of achievement of object of general public utility. So only those activities the Supreme Court has held are permitted as part which will not be prohibited by the proviso to section 215. And not only that, the Supreme Court further held that what is the meaning of the word consideration, cess, fees used in the said section. The Supreme Court has held that the cess, fees or any other consideration must be in lieu of rendering of any service or in lieu of any activity in the nature of business imparted to the recipient. If the fees or cess is received as a impost, as a statutory impost, not as a consideration. For instance, there are various statutory bodies, a water body, which is not providing any service to the person, but collecting cess as a statutory impost to provide water in order to recoup the cost of supplying water, then it is not a consideration. So that activity will not be prohibited under the proviso to section 215. So if an activity is carried on and just to recoup the cost of providing that activity with a nominal markup, the Supreme Court has held that that activity cannot be considered as an activity in the nature of trade, commerce or business. But where an activity results in receiving consideration beyond the nominal markup, then it will be in the nature of trade, commerce or business, which will be barred by the proviso. But if that activity is in the course of carrying on or achievement of the general public utility, then extraordinary profit is permissible. But that extraordinary profit must be within the limits of 20% of the total receipts as amended by the Finance Act 2015 with effect from 1/4/2016. So in that sense, the Supreme Court has categorically held that the subsequent amendment of Finance Act 2015 is a clarificatory amendment. In other words, it's a clarificatory amendment. It will be applicable retrospectively even to the earlier periods when this amendment was not made. So taking clue from that, the Supreme Court has held that this amendment will need to be understood retrospectively, and if an activity results in abnormal profits, then it must be within the range of 20%, and if it is within the range of 20%, then there will be no prohibition of the proviso. That organization can still claim exemption under Section 11. But if it is earning abnormal profits beyond 20%, then that for that year it will not be eligible for exemption under Section 11. So friends, two conditions. First, I cannot carry on any other business. The business or a commercial activity must be in the course of actual carrying out of such advancement. So for instance, my object is to provide marriage halls to weaker sections of the society. Now this is my main object, but in order to achieve or in order to feed that object, I carry on a completely unrelated business. Say, let us say a newspaper business, that the profits from that business will be utilized for running the marriage hall. That activity is not permitted under the proviso as interpreted by the Supreme Court. The Supreme Court has also held that Section 11(4) and 11(4)(a) will need to be harmoniously construed with the intent of the amendment. They are not distinct. Even 11(4) and 11(4)(a) on harmonious interpretation would mean that only those business activities can be carried on which are in the course of actual achievement of the charitable object. Any distant activity which is not in the course of actual carrying on will not even meet the test of incidental business. It may be an incidental activity, but if it is not in the course of achieving the main object, then it will, for the purposes of GPU category, it will be barred by the proviso to Section 215. So basically, the Supreme Court has given primacy to the proviso to Section 215 over Section 11(4) and 11(4)(a) of the Act, and therefore it is a condition precedent that any activity which is in the nature of business, trade, commerce resulting in receipt of fees, consideration should be in the course of achievement of the object of general public utility, and if it results in earning of extraordinary profits, receipts, and is not just mere recoup of cost with a nominal markup, then the overall profit or receipts should be within the range of 20% of the total receipts of the organization. So this is how, friends, Supreme Court has interpreted this new provision, and therefore the test of incidental business, property held under trust, will need to be given a go by. What we will need to see is whether the commercial activity meets the test of the amended proviso to Section 215 as amended by Finance Act 2015. That is, the business must be carried on in the course of actual achievement of the object of general public utility, and if it results in any profit, extraordinary receipts, then it must be within the range of 20%. So this is the ratio of the decision of Supreme Court in Ahmedabad Urban Development Authority. What are the important highlights of this decision? While rendering this decision, the Supreme Court has impounded certain important principles of interpretation. The first important principle of interpretation reiterated by the Supreme Court is the history of legislation. What was the background? What was the history of the amendment in the taxation of charitable organizations from 1922 Act till the present Act? The Supreme Court has analyzed various amendments and have come to the conclusion what was the true import behind the insertion of the proviso. So basically, the Supreme Court has reiterated that while interpreting a provision, a resort can be had to the history of the legislation, various amendments that have been made in the statute in the prior period. Then another new principle of interpretation that has been impounded by the Supreme Court, which is an important principle of interpretation, is not just the history of the legislation, but even the subsequent amendments. So what the Supreme Court has held, that if the subsequent amendments throws light on the reason behind the original amendment, what was the intent of the Parliament in introducing a provision, and it has been clarified subsequently by the subsequent amendments, then the resort can be had to the subsequent amendments to understand or interpret the principal provision. So for instance, in this case, while Finance Act 2008 introduced the subject proviso, but there was ambiguity in the interpretation of the same. So it was subsequently amended by the Finance Act 2012 and lastly by the Finance Act 2015. So the Supreme Court has relied upon the amendment by the Finance Act 2015 to understand the true import of the amendment by Finance Act 2008. So this is a new principle of interpretation that has been laid down by the Supreme Court in this case. And friends, the amendment by the Finance Act 2015, as per the circular, as per the memorandum explaining the finance bill, was a prospective amendment. It was a prospective amendment with effect from 1/4/2016. Despite that being a categorical prospective amendment, the Supreme Court, by applying the aid of interpretation of the legislative history and subsequent amendments, have held that amendment of Finance Act 2015 to be a clarificatory amendment. So in that sense, friends, this Supreme Court decision coming from a larger bench can also be resorted to interpret when an amendment can be a prospective amendment or when it can be called to be a clarificatory amendment. The third important ratio emanating from the decision is the reliance on the circulars issued by the CBDT. If you would recall in my discussion, one of the arguments of assessee was that when we read the circular, we get to know the intent behind the amendment, that is to only prohibit organizations with an object of commercial activity and not an organization having an object of charity. The Supreme Court held that the circulars are not binding on the courts. They may have persuasive value, that is at best only an interpretation of the department of a provision. But if that interpretation is in direct conflict with the plain interpretation of a particular provision, then the circular cannot be relied upon. So to that extent, there is a clarity, there is a departure from a normal understanding as to the binding ratio of a circular issued by CBDT. The Supreme Court has held that circular may have persuasive value to the department, but that circular is not binding on the department if it departs from the normal interpretation, literal interpretation of a particular provision. So this decision can also be flag posted to refer as and when the issue of binding effect of a circular would come in subsequent litigation. Last important reiteration by the Supreme Court in the said decision is on the reliance on the speech of Parliament. So the Supreme Court has again reiterated that the finance minister's speech at the time of introducing a particular finance bill is also an important aid of interpretation and can be relied upon to understand the true import of a particular provision. So friend, these are certain important highlights or important principles of interpretation that are flowing from this decision of larger bench of Supreme Court in the case of Ahmedabad Urban Development Authority. So friends, I hope I am able to articulate few the important nuances of this decision. What is the ratio emanating from this decision? What is the impact of this decision? Now I'll come to what is the way forward for charitable organizations after this decision. Certain important factors, highlights, which in my view are important, which needs to be adhered to need to be understood for a charitable organization for claiming exemption going forward after this decision of Supreme Court. First, friends, we need to clearly keep in mind that this decision has limited applicability to GPU category, that is category of achievement of general public utility. This decision of whether or not an organization is entitled to carry on a commercial activity is not at all applicable to per se categories, per se 6 categories, that is relief to poor, education, medical, yoga, etc., etc. So an organization incorporated to achieve the object of medical relief or education, which is seeking to claim exemption under section 11, is not barred by this proviso to section 215 if that organization carries on a business activity or an incidental business activity. That organization will still continue to be governed by the jurisprudence prevailing, dehorse this decision of Supreme Court. The aid available, the benefit available under section 11.4 and 11.4a will continue to be applicable, will be enjoyed by these organizations which seek to achieve per se categories of 6 objects. The limited applicability of this decision, the prohibition contained in proviso, the harmonious interpretation of section 11.4, 11.4a with the proviso is only applicable to last category. Friends, we had the decision of Supreme Court, a celebrated decision of Supreme Court in the case of Thati Trust, which had interpreted section 11.4a. In that decision, the Supreme Court held that an organization incorporated to achieve the object of education and is carrying on the business of publishing newspaper. The newspaper, the Supreme Court held, was an incidental business carried on to achieve the larger object of imparting education, and if its profits are deployed to achieve the purpose of education, then that profit will be eligible for exemption under section 11.4a of the Act. That ratio will continue to remain applicable to 6 categories. The Supreme Court has categorically held that pursuant to the amendment of the subject amendment of proviso to section 215 will not deviate from the ratio of decision of Supreme Court in Thati Trust. Thati Trust is applicable to the object of achieving education, but not to GPU category. So that ratio will continue to be applicable in case of achievement of objects of 6 categories. And then, friends, the last thing which we will need to see is that even if an incidental business is carried on in the course of achieving the object of general public utility, how to compute 20% profits. Whether the receipts are to be seen vis-a-vis total receipts of the organization, receipts from the commercial activity are to be seen vis-a-vis total receipts of the organization, or it is only the profits. The Supreme Court at page 172 para 96 has somehow held that profits from the commercial activity should be within the range of 20% of the total receipts. So whether it is the profits or it is only the receipts, whether the observation of the Supreme Court at page 96 para 172 could be considered as an obiter dicta or a binding interpretation of the category or the computation of 20% mechanism. So these will be few open questions or the fallout of the decision of Supreme Court in this case of Ahmedabad Urban Development Authority. I hope, friends, my talk would throw some clarity on this decision, will provide help to various professionals and to assessees who are engaged in computing tax liabilities of the charitable organizations. We need to amend our structure of carrying on these activities and also understand how to compute tax liabilities in future. I hope this talk will throw some light on that and will help in dispelling the confusion surrounding taxation of charitable organizations. I thank you all for a patient hearing of my talk and understanding the nuances of this decision. Thank you so much.